Hello, everyone, and thank you for joining us this afternoon for a virtual event to discuss the Great American AI Act and the proposal to preempt state laws regarding AI developers. All of us joining today appreciate the importance and the urgency, too, of Democrats and Republicans finding a bipartisan path forward on AI policy. However, many of us share the concern that such a path forward must not eliminate the one source of AI accountability that has actually moved while Congress has stalled, and that is the states. The Great American AI Act would block states from enforcing laws that regulate AI model development and pre-release safety decisions. That's the stage where training data is chosen, models are tested, risks are measured, and release decisions are made. Banning state laws on AI development would block a range of state laws impacting issues ranging from child safety to workforce protections to civil rights and corporate accountability. Today, we have with us experts in many of those fields who share a sense of alarm over the proposal for a 3-year moratorium on state AI laws. I'm Brad Carson. I'm the president of Americans for Responsible Innovation. Rather than speaking for our panelists, I'm going to give each of the experts joining us today a couple of minutes to introduce themselves and speak broadly to their concerns about the Great American AI Act and preempting state AI laws. After today's introductions, we will feature a short moderated discussion with our panelists, and then we'll turn to audience Q&A. If you are joining us here today, please feel free to put your questions in the Q&A function on Zoom, and I will direct them to the appropriate panelist when we turn to audience questions. If you're tuning in on X, please feel free to leave your questions in the comments. For introductions, let's start with Alejandra Montoya-Boyer, who is the Vice President of the Center for Civil Rights and Technology at the Leadership Conference on Civil and Human Rights. Alejandra, thank you for being with us today, and the floor is yours.
Thanks, Congressman, and hi, everyone. Thank you again for being here. I lead the Center for Civil Rights and Technology at the Leadership Conference on Civil and Human Rights, and we're the oldest and largest coalition of civil rights organizations fighting to protect, defend, and expand the rights of every person in the United States, including recognizing that right now AI policy and civil rights are inextricably linked. I want to start by highlighting a glaring omission from this bill draft. It lacks any mention of our civil rights or explicit protections against bias and discrimination. At a time when our rights are on the chopping block from an authoritarian administration, and that companies, and that our rights are also on the line at companies that develop these technologies, leaving civil rights behind is unacceptable. That omission means that people across the nation will be at risk for data-driven discrimination. People will get locked out of quality jobs, housing, educational opportunities, and healthcare, or can even be wrongfully jailed or imprisoned because of faulty AI systems that supercharge discrimination at massive scale and scope. I think we can all agree that we want to see Congress take these issues seriously and to pass comprehensive federal legislation. But it's clear that civil rights advocates must be at the table when legislators are deciding what to prioritize in a federal AI standard. Otherwise, our communities will continue to pay the price of unchecked AI adoption and deployment. Our issues deserve the same level of attention and protection as the harms that this bill seeks to solve. Our civil rights cannot and will not be an afterthought.
Alejandra, thank you so much. Now let's turn to Sara Nelson, who is president of the Association of Flight Attendants-CWA. Sara?
Thank you, Congressman Carson. I'm so grateful to be here. And as president of the Association of Flight Attendants, I also talk with workers all across the economy in building worker power to try to create a more fair economy. And we are experiencing one of the most unequal times in our entire history of the country. We know in the labor movement, first and foremost, that the people who understand how to solve problems are typically the people who are using it. So as we think about how AI is affecting every single different part of the economy, we have working people in their communities standing up and saying that they need change. They need this addressed. They need this addressed for health and safety reasons. They need this addressed for consumer protections. And those issues are not going to be taken on unless we allow the states to be able to create some of these ideas. If we look in our history through some of the labor provisions that have been implemented at the federal level, they've started in the states. If you think about workplace safety, one seminal moment in our history was the Triangle Shirtwaist Fire that happened in 1911. We did not see the formation of OSHA until 1971. This is after New York passed laws following that fire, but we did not see sort of a coordinated federal attempt to try to address workplace safety until 1971. So we cannot shut the states out of this process. We look at this in terms of our experience historically, but we also look at this in terms of our experience as working people, as the working class, understanding that at the federal level right now, there are people controlling our politics who want to destroy all jobs. They have said that the purpose of AI is to remove all jobs from the economy and to be able to run the economy with robots. That is their dream. That is their godlike dream. They have said that working people can sit around and play video games and receive a UBI check. I want to be very clear that working people across this country, the only majority that exists in this country, take very seriously the work that they do, the pride that they take in it, and they should be at the table. And if we exclude states from this process, oftentimes they will not have an entry point to be able to enter the AI discussion. So it's extremely dangerous. It's a hard no, and no one in Congress should be talking about state preemption at a time when we are talking about a revolutionary advancement in technology that should be harnessed for humans and not for just a few in the billionaire class. Thanks, Fred.
Thank you, Sarah. Now let's turn to Zamaan Qureshi, who's co-founder of the youth-led coalition called Design It For Us. Zamaan?
Thank you, Congressman, and thanks to ARI for putting this on. My name is Zamaan Qureshi. I'm the co-founder of Design It For Us. Design It For Us is a coalition of young people from across the US and around the world advocating for safer online spaces for our generation. We are over 550 young people in the United States from about 40 different states. And we are focused explicitly on safeguarding protections for our generation. Young people know how consequential tech policy decisions can be, which is exactly why we cannot afford to get artificial intelligence wrong. Having come of age alongside social media, we've seen what happens when companies build and release products without meaningful guardrails. These platforms offer benefits, but they've also turned our attention into a commodity, engineering products that keep us scrolling and in harm's way to drive their profits. AI companies are now barreling down that same reckless path, and their rushed deployments are putting our mental health, our economic opportunities, our education, and our collective future on the line. The regulatory failures that define the social media era cannot become the blueprint for how we handle AI. That is why we are incredibly concerned about the latest AI bill from Congresswoman Trahan and Obernolte that contains preemption of state AI laws for 3 years. We have worked on state-level protections for young people across the United States through age-appropriate design codes, through AI protections, through catastrophic risk protections. These are things that young people care deeply about and have spoken out to their state legislatures to urge them to pass these protections because Congress, up to this point, has failed to do so. Young people have also spoken out alongside parent advocates from across the country to urge Congress to reject sweeping AI preemption. We have also written to other lawmakers raising our concerns for young people. Sweeping AI preemptive measures would nullify states' rights to protect their residents from unchecked AI harms and undo much of the hard work that lawmakers and advocates have undertaken to protect consumers and young people. This bill in particular risks preempting state-level AI chatbot protections for young people, leaving them with none. And that is why we're respectfully calling on the lawmakers behind the Great American Artificial Intelligence Act to reject state AI preemption. Thank you.
Thank you, Zamaan. Now let's hear finally from Zephyr Teachout, professor of law at Fordham Law School, as well as an author and expert in the fields of antitrust technology. And as she takes the floor, let me remind people to now post their questions in the Q&A so we can quickly get those going as well. But Zephyr, the floor is yours.
Thank you so much for hosting this panel and raising this really essential issue. So the current draft of the bill preempts and forbids states from passing laws that regulate the development of AI. This is an incredibly broad preemption regime. Now, preemption, we're going to talk about mostly about AI, but preemption has long been a critical tool of power because it removes decision-making from the states, removes decision-making from, as Sarah mentioned, the people who are actually directly, most closely responsive to their constituents, from parents and children, teachers, as Zamaan was mentioning. So let's talk about what this means. This means if a state legislature decides that it wants to increase tort penalties for developers in response to significant AI risks related to chatbots used by children, the developers will argue that because this targets pre-deployment activity, it is preempted and the state may not engage in expanding liability for those developers. The language of development, which encompasses everything prior to deployment, is incredibly broad. There's a separate problem in the bill text, which is deployment is not precisely defined. We know that the AI companies would, and I'll return to this in a moment, would use this tool to attack and delay any state regulation, taking on our already overtaxed and underfunded attorney generals in red and blue states across the country and forcing them to defend democratically passed laws, arguing that it falls within this broad preemption. But let's again look at what this means. Let's say that there is a state law that wants to require pre-deployment safety testing. Preempted. Let's say there's wonderful work happening now at Vanderbilt and other places looking at ways that we can look at liability throughout the stack, the AI stack, and make sure that those actors that have the greatest capital in traditional American law, following traditional American law principles, those who are in the best position to avoid harm would be those who would be liable for causing that harm. Because this preemption law basically forbids state action below that app level deployment, it can prevent laws that force liability at those places where the greatest capacity to protect from harm, including the discriminatory harm that Alejandra was talking about, lies. The area which I work in, antitrust and anti-monopoly, there's a lot of interest at the state level in engaging in requirements to require, say, neutrality at some of the layers of the stack, neutrality at the foundation level, or separation of the stack. All of those would constitute pre-deployment regulations, basically removing from states their most fundamental job, which is economic regulations within their states. So this is an incredibly broad regime. And what you'd see in response to this kind of preemption regime was deeply capitalized foundation models where all the meaningful decisions about safety, content filtering, discrimination are made, and then thinly capitalized app developers who would be deploying. So then when a lawsuit comes along, only those using existing law, only those, or even new laws, only those thinly capitalized app developers would be liable. So it actually, the preemption regime that we see in this bill actively encourages a kind of hiding the ball on liability, and would lead to more dangerous activity in the development and I think it really should be a non-starter. The reason we're talking about preemption here, as opposed to other elements of the bill, is that the preemption is what makes this bill illegitimate as a democratic matter. As we approach the 250th anniversary of the Declaration of Independence, we have to return to the core principle of people governing themselves. And that means people being able to respond in real time to the most significant technological development in generations.
Professor Teachout, thank you. A reminder to people to please continue adding your questions to the Q&A. But let me start with some of the questions that are being posed. One is to you, Professor Teachout. You're a student of technology more broadly. A preemption provision like this will be litigated in the courts. Can you talk perhaps about how the history of such litigation, about Section 230 and others, might suggest risks, dangers about what courts could do to provisions like this?
Thank you for the question. Section 230 was a 1996 law that granted broad immunity to what was understood at the time to basically be neutral message boards. Those neutral message boards grew into Facebook, Instagram, TikTok, and YouTube. And all of those companies have then aggressively used Section 230 far beyond the reach of what it was intended to do to insulate them from tort immunity. So there's two really important lessons that we can learn from that. One is that we have now had 30 years in which tort law has basically been frozen in the internet space. And tort law is a deep foundation American way of making sure that those who are harmed have recourse for their harm. It's a really basic principle. We froze that in time. And so now as we're deploying this new technology, we actually lack the wisdom of those 30 years of liability that we might have gained. But second, courts overread the Section 230 provision. They read it far more broadly. They're actually starting to read it more reasonably in a series of cases, including in the important case where Meta was found liable for its the design of its social media interface. And courts are now looking more skeptically. But it's taken years for advocates and lawyers to actually be able to punch holes in that defense, in part because of the incredibly well-funded big law money that goes into defending these lawsuits. What we could expect to see here is that with this preemption provision, we can fight about. I think it's broad on its face for the reasons I said. I even think that the questions at the margin are secondary. The fact that you can't reach development is like saying you can't reach the people who are fundamentally making something. You have to wait till deployment. But even at the margins about like what constitutes deployment, what doesn't constitute deployment, is this tort liability law? You can imagine a state seeking to expand tort liability generally, and then the question is, was this designed to attack AI or not AI, or was it more designed as a child protection? All of those questions are big billing hour questions that cost millions and millions of dollars. And while those cases are being litigated, kids are getting hurt, people are getting discriminated against, and we're seeing harms that we do not even know of yet, with no real ability to address them. So I think that the lesson here, I'm sorry, I'm going on a bit long, but the lesson here is to actually return to sort of core American principles of state legislative power and liability regimes, and allow those to actually operate instead of choking them to death before we actually have a chance to let them play out.
Sara Nelson, a questioner asks if you could talk a bit about the fears that labor unions have, perhaps around hiring, scheduling, surveillance, workplace discipline, workplace monitoring, that you see your brethren in the labor movement concerned about. And one of the questioners asked specifically about flight attendants. How do you think AI is going to affect flight attendants and concerns you might have there?
Okay, thank you for that. We are already seeing surveillance of workers and HR decisions being made without a human interaction at all. If anyone has tried to return something to a major company today, have you had a simple way of doing that, or have you been stuck talking to a chatbot who doesn't understand what you're saying? This is extremely concerning. As in our movement, when we think about due process as a core part of a union contract, and what should be really in any union contract, and is also a core principle of our country, the idea of due process, that requires human beings to hear the circumstances surrounding the issue. And there is no way to do that when you have AI performing all of those functions. So we are really concerned about the way that AI has led to a real invasiveness in people's own private lives, in freedom of speech outside, away from the workplace, and being held accountable for those things. We are concerned about the way that people have been disciplined through a strict adherence to some code that has been written, rather than having what is supposed to be a human resources department interfacing with humans. And what that leads to is really very dangerous situations, because when workers, especially workers in safety sensitive functions, and I would include teachers, anyone on the front lines, the postal service workers, and then obviously the first responders and people working directly with the public. When you think that there is going to be no give in a decision that you have to make in an emergency situation, that can be a chilling effect on someone taking action to save lives or intercede to ensure that there's not violence or ensure that there are people not getting hurt. This can have a real chilling effect on just being able to deliver the services that what people would think are so necessary in their communities and in their workplaces. We have real concerns about that. We have concerns as flight attendants. We know that already we have moved away from certifying aircraft with the correct number of people who need to be on the planes to an analytical process of determining whether or not there needs to, how the cabin needs to be configured, how many people need to be there to evacuate people safely. And we also know that over the course of the history of our industry, it has been the unions on the front lines interceding to make sure that any safety regulations that go into place, because those are written in blood to start with, are only enforced because the unions are there to ensure that they are enforced. So when you cannot interface with anyone to be able to talk about those issues, that immediately not only undermines the safety in the workplace, but it undermines public safety as well. So we have very serious concerns about that. But we also, as flight attendants, we have concerns about Qatar already creating the AI flight attendant and moving to this idea that any job can be replaced by a robot or a chatbot, and that people don't really want to interface with human beings. And we know that that's not true. And as a core example, I'm sure people are tired of turning on the evening news and thinking that when you buy an airplane ticket, it's a brawl fest up there. It is not. There are thousands of flights that take off every single day because human beings, flight attendants, expertly de-escalate situations with humanity stuck together and working under rules that they're not comfortable with working under in their regular lives. And that's only possible when you have that human engagement and interaction and that human evaluation of what has happened, where the risks are, and trying to plug those holes in advance. You cannot have a predictive model that is able to do that. And so for all of those reasons, we are very concerned about preempting any ability for people on the front lines to be engaged in creating the regulation that is going to make this work for the American public. And I would just say one other thing. Many people around the world for decades wanted to buy the American product because it is that democracy. It is that engagement of the unions. It is that very thoughtful approach, democratic approach, where every voice is heard, that it created and the best safety provisions, the best manufactured parts. People wanted to buy that American excellence. And that came from democracy. That came from many, many voices being involved, and specifically labor unions enforcing it. So preempting all of that puts us on a road to not being able to compete with the rest of the world. We are being told that we have to hurry up to compete. No. Actually, we have to slow down and be thoughtful and put in place meaningful regulation that oftentimes will come up from the states, and we cannot cut off that process. Otherwise, we will fall behind the rest of the world.
Alejandra, let me come to you next. One of the questions people are asking in both the chat and more broadly is they'll say the bill only preempts laws about AI model development. It doesn't preempt generally applicable civil rights laws. Why is that distinction not as reassuring to you as it might sound to others?
Yeah, thanks for this. We've heard this before, and we keep getting questions whether about this specific bill and its quote unquote narrow preemption, or in other places where we've heard the critique that there's already civil rights legislation in place that can protect people from this type of discrimination. And that's just not true. Relying on existing civil rights laws is not enough to address the harms that AI is posing. Sarah was already detailing some of the ways it's impacting specific industries and workers explicitly. And the protections are just not enough when it comes to these technologies. The threat of being locked out of jobs or have job, worker surveillance and job degradation, like Sarah was describing, being, blocked out of housing, education, healthcare, all of these different types of spaces because of, I think I saw a question around black box algorithms or opaque algorithmic systems. The protections that we have in place just don't go far enough to be able to protect people from that harm, ensure that it doesn't happen, and more importantly, offer a recourse mechanism when this harm is, when someone experiences this harm. If you're denied a job from known discrimination, but you don't actually know that an AI system has been used, or the algorithm has a black box design, so you actually can't, pull apart all of the pieces, our current legislation is not equipped to handle that type of discriminatory process. The administration has also undermined other spaces that are, or other critical pieces that allow us to currently kind of attack these issues. So things like disparate impact has been under attack. This is a key legal protection to enforce existing civil rights when it comes to AI. So making sure that it's not just known discrimination, but it's also the outcomes. So if, we know that these systems are disproportionately impacting, for example, in the mortgage lending space, there's plenty of research that shows that when AI systems are used, Black communities are disproportionately left out of mortgage opportunities or have higher interest rates on their mortgages. That's an outcome. That's a disparate impact outcome, and yet the way that current civil rights legislation and this administration's attack on disparate impact means that we can't actually pursue legal recourse to respond to that type of discrimination. So it's just difficult to be able to, right now, like the way that these systems are built, it's very difficult to prove that algorithm was designed to intentionally discriminate against people. But we know that these systems are trained on data that, historically biased data. So people, redlining is a historical fact. We know that Black communities were left out of mortgages, but if the AI systems are trained on that data, it might produce an outcome that continues that type of digital redlining and makes sure that we continue that. And so the way that our legal structures exist right now are not enough. We need to be able to pass explicit legislation that responds to this growing challenge. And what we certainly can't do is preempt the few state laws that are, where the states have stepped up to try to protect people from these harms, with preempting this with a bill that does not even acknowledge this type of discriminatory impacts.
Let me just follow up with you there, because there's a lot of questions in the chat about this. You talk about existing civil rights laws. One of the reasons that we at ARI have opposed preemption is the belief that you need, in the age of algorithms, AI-specific laws. If you were discriminated against by some kind of algorithm, you would never have the ability under preemption to get the data or to understand the algorithm to actually prove your case that it was discriminating against you. Is that a fair summary of one of your concerns, at least?
Yes, that's exactly, to be able to understand the transparency and information that is required for individual people or workers or a class action, however this would play out. People are not given enough information to even know when these systems are being used against them, or to be able to fight back again, right now, kind of the structure that we're in, to be able to make these cases, we have to prove intentional discrimination, that a person is specifically denied a job because of their race or ethnicity or gender. That is extremely difficult in any case. It is made almost impossible with these AI systems. And so we need legislation that proactively assesses and audits these systems for the data and algorithms that they use, in the way that these decisions are made, and that requires some type of recourse mechanism for folks that are harmed, or we're able to show a disparate impact outcome that is keeping people of color or other marginalized communities out of jobs, homes, healthcare, etc.
Zamaan, let me turn to you. At Design It For Us, it's a youth-oriented organization doing amazing work. Tell me what you believe that a pro-innovation but pro-child safety AI bill would actually look like instead of the Great American AI Act.
Yeah, absolutely. This looks like protections for young people by design. So regulating the business model of how these systems are designed, and ultimately the kinds of conversations preventing against some of the areas of harm that we see around AI LLM. So whether those conversations are conversations that have been engaged around self-harm, suicide, eating disorders. We've seen some of these cases play out already, whether it's the case related to character AI or ChatGPT. And so we need more protections, not less protections for young people in this space. Right now, there are no laws on the books at the federal level governing how AI systems are supposed to be regulated as it relates to young people. And I saw a question in the chat as well around kind of the distinction around the preemption language and how it can affect some of the state protections that have been passed to protect young people online. The way that we see it is that trying to distinguish or create a line around development versus deployment is a very difficult thing to do. This has not been done in the law before. Development never really stops in an AI system. Models are constantly being developed. And to sort of think about this as kind of a regular algorithm where you can put into place some kind of filter just doesn't quite track across how we think about the ways that these very powerful models are being accessed by young people and the kinds of protections that we need to see. So in particular, when you have child safety laws that tell an AI system that in order to comply with the law, you have to ensure that your product does not engage in, say, sexual conversations with a young person, then the onus is on the AI company to build a product that doesn't engage in those conversations. And I am sure that they will say that that is some form of development. We also should expect, having seen the playbook over the past few years of social media companies, that these companies will use any tool in their toolbox to try and throw another legal wrench into the system and prevent some of these child safety laws from coming into effect. We've worked for years to try and pass age-appropriate design codes around the states that protect young people on social media through safety and privacy by design. And it is the playbook of these technology companies to sue every age-appropriate design code in the states from coming into effect and use the legal system to lock these laws from ever coming into full effect. And so, we do not need to be giving them another tool in their toolbox to try and challenge these laws as well. And we obviously appreciate the work that the bipartisan work to try and get AI protections done here at the federal level, but we have to also recognize that states have already done tremendous work up to this point as well, and there is no requirement that we undo that work in order to get strong federal protections done.
Zephyr, some of the people in the Q&A are saying this seems to be a narrow preemption. That's how they're characterizing it. We at ARI, I myself, don't see this as a narrow preemption. We see it as like a very broad preemption. But you're a professor of law focusing on these issues. How would you characterize this in this debate that's happening?
It's a very broad preemption because it only allows for state action at one final point, again, a little bit undefined, the deployment point, not clearly defined, but the deployment point in a very, in a multi-layer stack. The language of stack is often used in AI, but I think it's really important here because one of the things that the big AI companies want us to do is to see them as undifferentiated wholes. But just as like when you have I don't know, when you get boxed cereal, there's different stages in the development of that boxed cereal where the grain comes from, the processing, the packaging. There's all of those stages in AI development. And what this does is it says effectively, only at the app level can states pass laws. So let me just give you a few examples of how broadly this reaches. I started to. It certainly preempts anything related to industrial structuring, which is a big part, I think, of where we to regain democratic control over AI need to focus. But it would preempt speaking to different some of the different issues that have been brought up here and some that have not. A state from saying, we're really worried about discriminatory data being used to train apps used in medical services. We want to make sure that people are not actually subject to systems that are going to treat people in the way that Alejandra was talking differently because of their race, even though you can't necessarily identify a particular racial intent. So let's say a state says, okay, we want any AI system used in clinical diagnosis to prove that its training data is demographically representative. This is a really common sense law, right? Preempted. Let's say, speaking to what Sarah was talking about, we want to make sure that before we start engaging in nurse staffing, we don't deploy something that is going to have a big impact on nurses in the state. So we're going to say require developers to file a work impact assessment before a state labor department. Really common sense. It protects the well-being of the nurses, but also protects the well-being of the residents. Absolutely preempted by this. Or let's say, I'm from New York. People are worried about the artistic creations being stolen, the mass theft that's underlying so much of AI deployment. And so the state says, wait a second, we want to do something to protect our artists and protect intellectual property in our state. So we're going to say something like, no AI can be trained on copyrighted work by our state residents. Brad, these are just 3 ideas I came up with in the last 15 minutes while thinking about getting ready for this. And this is just the tip of the iceberg. And then for what Zamaan is talking about, let's say that we want to make sure that that everybody in the supply chain is liable for kids who are killing themselves because of the models, not just the app developers. And I just want to put something I said before. If I'm an AI company with this bill, what I'm going to do is make sure I hide and protect capital from anything the state can do. We're not in a static system. We're in a dynamic system, right? And so then you have forward-facing apps that are discriminatory, and they say, okay, you regulate those discriminatory apps, but all the capital is hidden behind the shelf. So we should look at this the way that a corporation looks at it. Liability, responsibility, capital, those all have to go together. And these are some of the reasons why I see this as incredibly broad, because it preempts health, child safety, restructuring, anti-discrimination, and all the creativity that comes at the local level where you actually see the harms.
Alejandra, let me come back to you. Tell me at the leadership conference what you would like to see in a legislative framework for artificial intelligence. What are your ambitions for that?
Yeah, I mean, as I said at the start, the heart of this bill for us has to be civil rights protections. And so what do we mean when I say that? As I was talking about, safeguards that are going to make sure that bias and discrimination is not a part of the AI systems that are being both developed and deployed. So creating assessments that check both the data and the algorithms against bias and discrimination, mandating those assessments. This is not an opt-in process for companies. Making sure that there is, as I said before, a significant path to recourse when these AI systems do harm people, and that people know how to access that recourse. That if there is known discrimination that happens or other types of harm, there's a path to ensure that companies are held accountable against that, and that companies are fixing that. They're not just paying off against these problems, but they're responding with accountability to change the tools, so they no longer harm people in that way. We also need to ensure that there's true transparency when AI systems are being used, how they're being used, in what ways the data collection that maintains AI systems are being used for people. The professor was just speaking about the massive amounts of information from artists, creators, all of these things. We have to make sure that there are protections in those ways. I also think we need to be thinking about things like worker protections, not just the surveillance tools that are being used against people, but people's jobs are on the line here. We've heard these billionaires talk about job displacement as a known fact. We need to make sure that workers are protected, that we're providing paths to new jobs, we're upskilling people, and that those pathways are as diverse as the United States is. And so, we have a long history of, changes in workforce that disproportionately impact people of color, women, and other marginalized communities. And so making sure that when we are making workforce investments, we're making them in places like with partnerships with HBCUs, with civil rights organizations, with workforce development organizations that know how to target and train those folks. There's already legislation from the AI Civil Rights Act that lawmakers can look to see explicitly what we mean when we're saying civil rights need to be at the heart of any federal comprehensive legislation.
Sara, let me come to you. We've already talked a bit about this and you've addressed it earlier, but can you be more explicit about what you would say to a member of Congress who believes this is only about regulating the developers, what Zephyr called the apps, and not workers? How do the decisions made before even deployment of those kind of things shape what's happening to workers on the job itself?
Yeah, so when you preempt any engagement, I mean, I think about just fundamentally when we are new on a property and we are sort of teaching management how to work with the union, there is oftentimes a lot of pushback at first, and we have to really fight our way in. And sometimes this happens again when we have turnover in management, so we have to do it all over again at various companies. But when we work at our best, is when management understands the value of working with the union to bring the issues from the shop floor, that's metaphorical too, in any working condition, from the shop floor, to those conversations about how to make the company work at its best. And I want to be really clear. I think Zephyr's point about capital and how we need to be thinking about this from the company's perspective, I've had many CEOs say to me throughout the years, you know what, you make a good point, but my board wants to make sure that we can get every last dollar so that we can send the stock buybacks and to Wall Street. And so there is this constant pressure to not do the things that are going to be good for the consumers or for the workers who are working there. And there has to be a counterbalance there. And if you cut off the opportunity for that counterbalance, you are essentially cutting off any ability to be able to have a determining factor that is something other than simply making another dollar, earning another piece of revenue, and actually making investments in our communities, in our companies, that will actually make them good for the long term, and are not just focused on that next quarterly earnings call. So I may not be answering this, very, very specifically about what workers are facing right now, but I am thinking about the civil rights in the workplace. If we don't bring these issues forward and force these issues with the corporations, there are people who simply do not experience the kind of bias and discrimination in their lives who are making decisions most often, because most often it is one class of people who are the decision makers, and it is a whole other diversity of people who are actually delivering the product. And it is only through a space where you can get those minority views and those voices to come forward to be able to consider what people are working with. So for some of my members to be able to come to work, it's a lot harder for someone who is a single parent having to deal with childcare. These are issues these are decisions that they're making. I think about the flight attendant and pilot partner, who the flight attendant is taking more sick leave because very often it is a woman. Very often the pilot is a man, and the man is going to work because they're going to get their family is going to get the higher paycheck from that man going to work. The woman has the lower paycheck, and also she is often defined in that marriage structure as the one who is taking care of the kids, checking on them when they're sick. It is more likely, we have a harder time as flight attendants to bargain for sick leave, for family leave, for all of these provisions. If you extract any of that dialogue, if you cut off the ability to have those conversations, we are going to go further and further back in time. We are going to have fewer people included in decision makings, fewer people included in our economy, fewer voices to be able to identify where people are getting hurt. And, anyone could sit here today. I talk to people all the time, men all the time, who say, not for my daughter. I don't want her in this unsafe work environment. Not for my daughter. But if you don't give your daughter the power of a union to be able to fight against the sometimes not even ill-intended, but biased approach to what that daughter needs in the workplace to be safe, then we're not addressing sexual harassment. We're not addressing the power dynamics that often keep women and people of color at a disadvantage. And what that does is it means fewer and fewer people are participating. And I'll just put this in terms of, and capital will never discern this because of the short-term decisions that are being made only based on revenue or cost cutting. That means, for example, in the airline industry, I'll give you a very good example. Spirit Airlines just went out of business. Oftentimes, that was the entrance for many people to fly for the first time. If you are not including people, you are not expanding your product base, you're not expanding your consumer base, and it is a failure for those companies. But there is nothing in those companies and the regulations right now that make them have to consider those things. So I think about what we experience right now and how this could be supercharged and even be worse in an environment where AI is being developed and deployed without any real very productive and intentional efforts to make this work for everyone and to help people do their jobs rather than replacing those jobs.
Zephyr, someone in the chat is asking about the issue of data privacy. And it comes in the context of, we read lots of stories where employers are tracking the data that their employees are creating. Call centers, we know that those conversations are taped and used to train models. We have Meta doing keystroke logging where they can actually understand what all the employers are doing. You can imagine a state wanting to pass a law to prohibit that in some way, but that could affect training data, the data layer or something. Tell me what you think broadly about this phenomenon, how the law could react to it, and how it might play into preemption in some way.
Yeah, I've actually been somewhat involved in state law efforts. Colorado just passed, but then the governor vetoed a bill prohibiting surveillance wages, which prohibits the use. It's a deployment level law. The use of PII, of personal information to set wages, like you are going through a divorce, therefore you're likely to be more desperate. You should not get paid less because of basically of desperation data. And we know that there's been an explosion starting in 2020, and there's basically 3 stages in management tech. And the most recent explosion, which I think Sarah was talking about earlier, a highly intrusive tech. A lot of the data is being collected. It's still a black box in terms of how it's being deployed. Certainly, we have every reason to think it's happening in both for hire cars and in the nursing economy. There's a recent report out about nurses who have to share data, including their credit scores, and then get paid different amounts, and sort of a gig nursing model. It is not only likely to exacerbate existing racial inequalities, exacerbate inequalities themselves, but it's deeply, deeply dangerous for our democracy. Because when people are isolated and treated differently based on intimate personal data, their own anxieties, and how that, basically your wage is treated like your TikTok feed, that separates each of us and makes people fearful about speaking out. Because what if the reason they got a few dollars less per hour yesterday is because they're constantly recorded, except in the bathroom, voice revealed some political preferences, and that rational paranoia gets embedded in our system with surveillance wages. I think it's critical to ban those surveillance wages. Now, what the advocates of the Tran bill would probably say is go ahead and do that. But when we're approaching surveillance wages, it's important to not just look at that, deployer level liability, right? So as we address this, I see AI as potentially fundamentally reordering the market, where everybody gets surveillance wages and prices in a way that is democracy destroying, as well as really dangerous for stable wages and a fair treatment. I think it's a really big deal. People have different views about AI. But the ways in which we should engage with this potential threat are not just at the deployer level. So a state wanting to engage at this level, I just want to reiterate this. It's so important. If I'm a lawmaker, I'm going to start with the idea, really, really basic idea. Liability should flow from the entities that have the power to prevent the harm. Really, really basic idea. And so I would look down the stack and I'd say, okay, who has the power to prevent harm? Maybe I say certain kinds of data can't be trained on, so that I can't learn that people who are going through a divorce are going to be more sensitive for their reservation wage. Like there's so many, if I think of the stack, it's like there's the data, there's the foundation model, the application model, and the deployer. And strong legislation has to address each level of the stack. But frankly, the foundation model of those is one of the most important, and that's where we're going to see a lot of new legislation as we start to address surveillance wages and the underlying architecture that allows surveillance wages and their discriminatory impact to happen.
We're coming up to the end of our hour, so let me ask a concluding question that a couple of people in the chat have raised. We're just going to go across the panel to conclude our session today. That question is, given the ideas that we've talked about protecting society and building a more equitable AI economy, what do you think is the most important next step or next few steps for moving all of this work forward? So Alejandra, you started today's panel. Let me come to you first to answer that question.
Yeah, and I'll repeat what I started with, that we need to make sure that civil rights are at the heart of this legislation, and not this legislation, any legislation that moves forward for a federal comprehensive package, AI federal standard, whatever language we're putting on it. Civil rights need to be at the heart of it. In the previous question, I kind of detailed what that means for us. But I also think we need to make sure that we're building out a coalition, a broad coalition of people to respond and make clear to our folks, that our representatives in Congress, how important this is. There's public polling, there's conversations around data centers. There's so many ways in which people have shown how important AI is and the impact that it's having on people's lives, for better or worse. And so I think we need to be able to make clear and use our already existing coalitions of groups to really make, our folks in Congress need to be able to respond to this, and that the response can't be, we're going to preempt the hard work that's already happened to protect people. It needs to be, we will provide protection, much needed protections for people in this issue. We will make sure that companies are held accountable when these technologies harm people, and we will have a conversation, I think Sarah was getting to this point, that is responsive across all levels, that people that are impacted by this are at the heart of that conversation and driving forward a policy that is not about companies or profit, but it's putting people first.
Zamaan, you represent young people. What would you recommend?
I think the diversity of constituency groups that you see represented on this panel says a lot about how people feel about preemption, how they see AI preemption affecting their lives, but also the need that we are hearing from our constituencies to advance AI protections at the federal level. And the two can happen in tandem with one another. We can have both strong state protections and strong federal protections. It is quite simple and straightforward. And so, at the end of the day, that's what we are calling for Congress to do. We recognize the moment that we're in with unchecked AI systems and the guardrails that are currently lacking for young people, but also young people have been burned again and again by a lack of policy moving quickly enough, and also in a way that safeguards the protections that have already been on the books for us. We know we are all too familiar with the playbook around social media and how that has left us without protections, and we are only just coming around to seeing those protections come into place at the states. The other thing here is that we also recognize how powerful these AI systems are to affect our society, our lives, and completely uproot the status quo as we know it. And while there is so much promise around innovation and the power of this technology is exciting, it also carries a lot of risk. And we need to be thinking about that risk in a critical way, because ultimately, for us, for the young people that we represent at Design It For Us, it's our future that we're talking about here. We're the ones who are going to live with the ramifications of these decisions, and we're the ones who are going to have to figure our way out of them. So I appreciate everyone being here to have this conversation. I encourage and urge Congress to keep taking action in a bipartisan way, but do so without nullifying the rights of states. Do so without nullifying the rights and the voices of young people.
Sara Nelson?
Well, I would echo all of my panelists. I think that it has been well said, but let me just be very plain about it. AI should be used as a common good for humanity, period. And the only way that that is going to happen is if we have a space for everyone to come to the table to work on it. And cutting off those ideas or that debate is only an effort to try to treat AI as a money-making proposition as opposed to something that can be used to improve humanity. I look at flight attendants are likely to have higher rates of cancer, even though in general they are more healthy than the average American. I think about what could be done to assist in finding cures and helping people who are humans on the front line, taking care of other people, do their jobs, not make it harder for us to do our jobs. We are already experiencing that because of the efforts to try to extract as much as possible from the economy, to extract as much profit and not be thinking about the human consequences. We already have experts on the front lines, doctors and nurses, being told that they can't provide treatment because the insurance company won't provide support for that. That is exactly the kind of thing that will go into hyper function in every area of our economy if we don't demand that AI policy starts first with improving the human condition and engaging everyone in that process, bringing everyone to the table for it. Preemption is a non-starter, and we have to be very clear about that. It is anti-democratic, it is anti-human, it is a positive future for our children. So this just, full stop. This has to stop. And then we can get to the place of actually talking about how we can create policy that is actually going to assist us in living our lives, assist us in doing our jobs, assist us in caring for other people, and dare I say it, assist us in demanding peace.
Professor Teachout, the last word to you.
This is such an important panel. 70 to 80% of Americans think AI is going too fast. As Sara said, there's extraordinary capacity here, right? Beautiful capacity here. But part of the reason that people think it's going too fast is they feel totally out of control, that it is a technology being done to them instead of a technology serving them. So to me, and I really want to echo these wonderful panelists, we should be talking about splitting up the stack, basically making sure that we actually can have a process where the foundation model doesn't own the application, doesn't own the data, doesn't own the chips, and that we can start to exercise democratic control. I want that to be on the table. But I really agree with Sara that when you have a deeply felt and understandable sense of anxiety and being out of control, the last thing you do is take away more control. So preemption would amplify the existing sense of powerlessness and fear and being subject, not governor of our own lives. And so instead, we should start where Zamaan is, which is federal and state. Experiment, respond to where the harms are, free our lawmakers to actually do their job and have a democratic AI.
Well, thank you guys for being on the panel today. Zephyr, Sara, Zamaan, Alejandra. For all of the people who have joined us as part of this, thank you for spending your afternoon with us as well. You can learn more about our work at ari.us. I'm Brad Carson. I wish you all a good afternoon and keep up the fight.